Hello, my name is attorney Rachel Moss, and I am here with attorney Emma Whitman.
We are going to be talking about another important case. This case is Reese versus the ATF, and it is actually striking down a current federal law which bans handgun sales by FFLs to individuals who are 18 to 20.
Yes, that's right. We just can't stay away from these Bruin analysis cases. But this one specifically deals with a challenge to USC 922B1 and C1. Together, they prohibit FFLs from selling handguns to 18 to 20-year-olds. And this, I think, was a pretty interesting case. I loved this analysis by the Fifth Circuit. They even got a little sassy at times towards the government, which I personally always love to see. But really, where this case stems from is, for a while, there was a case called NRA 1. And in NRA 1, the Fifth Circuit has actually upheld these laws previously. But after NRA 1 was decided, then came our favorite cases, Bruin and Rahimi. And the court has realized that Bruin and Rahimi are incompatible with their decisions from NRA 1, as well as the fact that NRA 1 would now be pretty much inconsistent with the Second Amendment. So in this specific case, it was originally heard in district court. The Fifth Circuit has decided to reverse the district court judgment and remand it back to the district court to make a decision compatible with their ruling here. So this case started when the appellants filed their case against ATF. They argued that ATF's regulations, as well as these laws 922B1 and C1, infringe Second Amendment rights and deny equal protection under the law to these individuals. So the appellants in this case were individuals between the ages of 18 and 20. And then there were also pro-Second Amendment organizations like the Firearm Policy Coalition and the Second Amendment Foundation helping the case along a little bit. So in 2021, the government had moved to dismiss the case under summary judgment, basically saying that they'd presented enough evidence here for the court to make a decision. And the district court did end up granting that motion, which is how we got here. So the appellants ultimately timely appealed the case, and this is how the Fifth Circuit considered it here. So the appeal, again, was abated pending the Rahimi decision. But once Rahimi was decided, they decided that this reinforced and refined the Bruin analysis, and they could then move forward with deciding this appeal. So to go over what these statutes actually are, we can look at 922B1 and C1. These statutes were part of the Omnibus Crime Control and Safe Streets Act of 1968. So I'll just read each provision to you. So 922B1 states it shall be unlawful for any licensed importer, licensed manufacturer, licensed dealer, or licensed collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has a reasonable cause to believe is less than 18 years of age, and if the firearm or ammunition is other than a shotgun or rifle, or ammunition for a shotgun or rifle to any individual who the licensee knows or has a reasonable cause to believe is less than 21 years of age. Then 922C1 prohibits FFLs from selling such a firearm to a person who does not appear in person at the licensee's business premises. Following these laws, ATF then implemented regulations prohibiting the sale of firearms other than a shotgun or rifles to those that are between 18 and 20. Again, as I always like to say, ATF was doing what they love to do and over-regulating firearms and regulating things that they have no business regulating.
Yeah, so this court definitely applies the Bruin standard here. They take a look at, was there a historical analog at the founding, which they determine no. And then they take a look at, are they the people protected by the Second Amendment? And they ultimately say, yes, they are.
Yeah, and it's really interesting to dive in and see how they made this decision. It's actually pretty similar to what we talked about in the last 2A roundup, where they had to analyze, are these individuals part of the people that the Second Amendment talks about? And they actually used pretty similar reasoning as in the range case that we talk about in our last video. It's similar to the range case where they found that basically every time the people is referred to in the Constitution, it means probably the same thing. And here, in this case, the court points out the fact that when we hear the term the people, typically it's understood to apply to everyone, pretty much all Americans, everyone who's part of the political community. So, for example, there's no argument for most people that the Fourth Amendment would apply to you regardless of the fact if you're 80 years old or 18-year-old, or even if you're a minor. The Fourth Amendment, the First Amendment right to speech, that still applies even if you're a child. These amendments still apply to you, so why are we treating the Second Amendment different when it says the people? Why would 18 to 20-year-olds be excluded from the people when in everywhere else, every other individual right, like the Second Amendment, would apply to them?
Yeah, and I found it interesting, too. They definitely did a good analysis on different laws at the founding and what was permitted or not permitted, and they talked about specifically military, and individuals were allowed to serve in the military starting at 18 and in some instances even at 16 or younger, and they were handed a firearm and permitted to have that firearm in that sense. They also talked about, okay, well, what about individuals who are serving in government? Is there age restrictions that are permitted on that? And at the founding, there were some instances where you had to be well into your 20s before. And so the court had to take a look at what was presented from both sides as evidence of historical analogs or the lack of, and make a determination. And I think the court absolutely ruled correctly in this case.
Yeah, I think they did a really good job at pointing out where the government failed to meet their burden here. Because the government pointed to limitations on young people for things like serving on juries. They said, yeah, there were times in our nation's history where 18, 19 wasn't old enough to serve on a jury. But then they really focused on the fact that has nothing to do with firearms. Serving on a jury isn't the same thing as owning a firearm. So I think the court was spot on in their analysis here. And I'm glad they recognized, yes, 18 to 20-year-olds, you are part of the people intended to be protected by the Second Amendment. So with that, they were able to conclude that the Second Amendment's plain text does cover the context here. So that means the Constitution presumptively protects the conduct. So that means the next question is whether restricting 18 to 20-year-olds from purchasing handguns is consistent with this nation's historical tradition of firearm regulation. And again, this is where both sides have to go through and flip through their history books and point to historical analogs. And it's pretty interesting to see what the government does versus what the appellants do here. And I liked how this court phrased it, that the government almost worked backwards in a way. They started with 19th century provisions, more modern regulations prohibiting 18 to 20-year-olds, and then tried to find things going back a little bit further that somewhat mimicked it, but not really. The government did one of their favorite things that they like to do in all these Bruen-Rahimi cases and point to racist restrictions to justify their regulations, pointing out, well, black people could serve in the militia but couldn't own firearms, so that's a restriction. Just like young people could serve in the militia, that doesn't necessarily mean they could own firearms. And the government would try to justify it on these sort of grounds, but really most of their grounds came from modern, more 19th century regulations, where the appellants recognize the fact that if you look at the actual founding era, what Bruen encourages you to do, in the founding era, there were not really restrictions on 18 to 20-year-olds owning or possessing firearms. So an example of one provision that the government cited to was restrictions prohibiting university students from carrying firearms. And the Fifth Circuit wisely pointed out that this applied to all students. It didn't matter if you were an 18-year-old student or maybe a little bit older, like a 25, 26-year-old student at the university. This restriction applied. So it wasn't really an age-based restriction. It was a location-based restriction. And they even noted the Supreme Court's caution against construing the sensitive spaces category too broadly, saying it would eviscerate the general right to publicly carry arms for self-defense. So again, at the end of the day here, the court found that the government's proposed founding-era analogs did not meet the burden here, and that the more modern regulations, while a bit more convincing, the Fifth Circuit did note that the 19th century regulations that the government cited to actually were relevantly similar. But they said that the founding-era history outweighs the more modern history. They made the point that not all history is created equal, and we're really supposed to be looking at the founding era. The Fifth Circuit even points to Amy Coney Barrett's concurrence from Bruen, saying, history that matters most is the history surrounding the ratification of the text, that backdrop illuminates the meaning of the enacted law. And I think that's a great point here, that when we're trying to understand what the Second Amendment was meant to be, maybe we should look at the circumstances surrounding that time period. And that's exactly what the Fifth Circuit did here. By going chronologically, they did consider the founding era as well as the more modern regulations, but ultimately decided that if we really are looking and giving more weight to what happened at our nation's founding, we can see that 18 to 20-year-olds were carrying handguns. They were allowed in the militia, and the Second Amendment was designed to protect the right to have a militia where people could keep and bear arms. So just looking at that historical context, we know that the founders intended to include 18 to 20-year-olds, and these regulations that, while they are a little old, started in the 1850s when we started seeing these types of regulations against 18 to 20-year-olds. While they've been around for a good amount of time, for a really large part of our nation's history, we didn't have these regulations. And that part of our nation's history should be given more weight when determining whether or not these regulations are constitutional.
Yeah, I think that was a fantastic point that was made in this case. And I find it just so fun watching all of these decisions come out, relying on Bruen, Rahimi. I feel like I'm learning a lot about historical traditions and analogs and laws at our founding relating to firearms laws and regulations. And I think we're just going to continue to see cases come out throughout the year with further decisions.
Yeah, exactly. And I'll end on this note with the Fifth Circuit's own words. I just love how they put it. The federal government has presented scant evidence that 18 to 20-year-olds' firearm rights during the founding era were restricted in a similar manner to the contemporary federal handgun purchase ban, and its 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. What a great way of putting it. That's why this case was reversed and remanded, and they found that 922B1 and C1 are unconstitutional. I think their analysis here was great. Another case that I am excited to see, I have to assume the government's appealing here and we're going to see it travel up to the Supreme Court one day. But I think we have a good Supreme Court to handle this case. I have a feeling the Supreme Court would agree.
I think so, too.
And another prediction, if it does go to the Supreme Court, Thomas is writing that opinion. And good news to all of our AOR members out there. If you haven't heard already, our program is now covering red flag laws. That means in your state, if someone gets an extreme risk protection order against you and your firearms are removed, we can step in and help. And if you are not a member of Attorneys on Retainer, you can check us out on attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program where if you find yourself in a self-defense incident, your legal fees will be covered. So check us out again on attorneysonretainer.us. If you want to learn a little bit more about our law firm, Attorneys for Freedom, you can check us out on attorneysforfreedom.com.
And if you liked this video, you know what to do. Like, comment, share, subscribe. Cheers.
Cheers.